All right, we're back on record, and the jury has informed the bailiffs that they have reached a verdict. I will put on the record that after conferring with the attorneys at 12:30, I sent a note back to the jury, said to the jury, it's now 12:30 p.m., would you like to take a lunch break for an hour or so? Judge Koss, and the return was no, not yet, one more issue to discuss. So apparently that was enough. So, Mr. Reno, if you would bring the jury in, please. Go ahead, be seated. Okay, so thank you. Be seated, please. Let's see, Mr. Beaton, you're the foreperson. Yes. You would hand the verdict forms to the clerk, please. All right, Mr. Hodson, if you would read the verdict forms, please.
Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23CR11, verdict, count 1, engaging in a pattern of corrupt activity, revised code 2923.32A1. We, the jury, having been duly impaneled and sworn, find the defendant, Richard Wayne Johnson, guilty of engaging in a pattern of corrupt activity, a first-degree felony, as he stands charged in count 1 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23CR11. Verdict, count 2, aggravated trafficking in drugs, Ohio Revised Code 2925.03A2. We, the jury, having been duly impaneled and sworn, find the defendant, Richard Wayne Johnson, guilty of aggravated trafficking in drugs as he stands charged in count 2 of that indictment. We further find that the amount of methamphetamine involved was equal to or exceeding 50 times bulk amount, but less than 100 times bulk amount. Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23CR11. Verdict, count 3, aggravated possession of methamphetamine, revised code 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant, Richard Wayne Johnson, guilty of aggravated possession of methamphetamine as he stands charged in count 3 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding 50 times bulk amount, but less than 100 times bulk amount. Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 4, aggravated trafficking in drugs, Ohio Revised Code number 2925.03A2. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of aggravated trafficking in drugs, a 5th-degree felonies, as he stands charged in count 4 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 5, aggravated possession of drugs, Ohio Revised Code 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of aggravated possession of drugs, a 5th-degree felony, as he stands charged in count 5 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 6, possession of cocaine, Revised Code 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of possession of cocaine, a 5th-degree felony, as he stands charged in count 6 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 7, receiving stolen property, Ohio Revised Code 2913.51A. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of receiving stolen property as he stands charged in count 1 of the indictment. We further find...
That should say count 9. Yeah.
Count 9?
Yes.
Okay.
I'm sorry, count. Which one are you reading?
I'm reading 7.
7, okay. Should be stands charged as count 7.
Count 7 of the indictment. We further find and specify that the property involved was a motor vehicle as defined in ORC 4501.01. The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 8, receiving stolen property, Ohio Revised Code number 2913.51A. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of receiving stolen property, a 1st-degree misdemeanor, as he stands charged in count 8 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 9, aggravated possession of methamphetamine, Revised Code number 2925.11, alleged value. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of aggravated possession of methamphetamine, a 5th-degree felony, as he stands charged in count 9 of the indictment. The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 10, aggravated possession of a fentanyl-related compound, Ohio Revised Code number 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of aggravated possession of a fentanyl-related compound, a 5th-degree felony, as he stands charged in count 10 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 11, possession of cocaine, Revised Code number 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant Richard Wayne Johnson guilty of possession of cocaine, a 5th-degree felony, as he stands charged in count 11 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Richard Wayne Johnson. Case number 23-CR11. Verdict, count 12, forfeiture. We, the jury, having been duly impaneled and sworn, find that the following items listed in count 12 are subject
Are or are not, as indicated. Yeah.
are or are not subject to forfeiture as shown on the written finding inserted next to each item due to its being used in and intended for use in, derived from, directly or indirectly, or realized through conduct in violation of count 1, of which we have found the defendant guilty. All
54.
All 54 items are marked as R.
All right. Thank you, Mr. Johnson. All right, ladies and gentlemen of the jury, you have heard the clerk read the verdicts. Is this the verdict of each and every one of you as to each of the verdicts that have been read? Is there anybody that no longer wishes to stand by those verdicts? All right. Anything from the council regarding the verdicts?
No, Your Honor.
All right. Thank you. Ladies and gentlemen of the jury, I will then accept your verdicts and enter findings of guilty in counts 1 through 11 and in favor of the forfeiture as you've ruled. I want to thank you for your service. It's been a day and a half and was a lot of information and a long jury instruction and a lot of decisions to be made, and you were very attentive and did your duty, and we appreciate that. So you'll be excused from, at this time, you are now released from the obligations and instructions regarding discussion of the matter or research or whatever. You're not required to talk with others about it, but if you wish to, you may do so. The clerk will have your vouchers and any work excuses you may need downstairs. Again, I want to thank each of you for your service to the community and wish you a good holiday weekend. So you can be excused. Parties will remain in the courtroom. Thank you. Yeah, don't forget to pick up your cell phones there in the windowsill. Thank you. Everybody may be seated. All right. Johnson, you've been found guilty. Or the court, your bond is revoked and you're remanded to custody at this moment. Now, I'm going to go ahead and proceed with sentencing, but if you would like to have, well, first of all, do we need to take a break to notify the victims of the sentencing, or did they wish to be present?
No, Your Honor.
They do not need. They did not wish to be present.
No.
Okay. All right. Now, do you want to have a few minutes to talk with your client before we proceed with sentencing, or do you want to go ahead and do it now?
Your Honor, at this time, I have not been given permission to waive a pre-sentence investigation report.
Well, you don't have a right. He doesn't have a right to it, so I'm not going to order one because it's a mandatory sentence. So
Absolutely.
it would be. There's no reason for it. I don't think that anything that would be in there would be of any great benefit to the court. So.
Then I would ask for a few minutes with my client.
All right. We'll recess for 15 minutes then. Thank you. Go ahead and take him into custody, but he will be permitted to talk with his attorney in the jury room. Well, Dan, you want to go ahead and clear out the jury room? Make sure there's nothing back there. And then they can talk back there. All right, back on record on State versus Richard Wayne Johnson. The jury has returned a verdict of guilty as to all counts, along with findings in count 2, 3, 4, 5, and 7. Now, based upon the court's analysis, it would appear that counts 2 and 3 and 4 and 5 would merge, and therefore the state would be required to elect which count to sentence on. Which count would the state be electing to sentence on?
The state will elect a sentence on 2 and 4, Your Honor.
All right. On behalf of the state.
Your Honor, I would ask the court to impose a substantial prison sentence in this matter. I would note a few things, just for consistency purposes for other defendants similarly situated, the most recent being Wesley Howard and Chris Hertzler, who were sentenced to substantial prison terms for their very, very similar cases. I would also note, and would want to make the court aware of this, just with the evidence that was presented over the last day, it would sound like we only learned about Scooch Johnson in June, but that is certainly not the case. The name Scooch Johnson is a name that Investigator Sanders has told me for a while. Somebody that we knew was moving a substantial amount of ice in this county, and sure enough, he was. The names in the ledger books, I know the court's familiar with some of the names that were said yesterday during the testimony. This is someone that was trafficking to a large number of people in this county. I would also say, and this somewhat came out yesterday, when Investigator Sanders was asked why it was decided to go ahead and serve a search warrant, because we had only done 2 buys, which is not typical for how we operate. We usually do more than that. But and he said, because the neighbors said, you've got to do something. This is out of control. And it was out of control. The amount of traffic, the amount of property that was coming up missing, it was just nonstop. And that is why they didn't build more buys. They just went ahead and served the search warrant, and we found what we found. We had absolutely no prior knowledge that the day that we hit that door that they would have re-upped the night before. So that's how often they were getting that amount of dope in that house to resell, because we just randomly hit on that day and they had just re-upped the night before. I would just ask the court to take all of those things into consideration when sentencing this defendant. Thank you.
All right, Ms. Mimsy.
Thank you, Your Honor. Would you allow my client to remain seated?
Pardon me?
Would you allow my client to remain seated at this time?
Sure.
Thank you. Your Honor, Richard has always been adamant with me that he wanted to exercise his constitutional right to have a trial, and now is his opportunity to really speak with the court through counsel. Richard knows that what was going on was wrong, and he absolutely got tangled up in the net that the state spoke of. I think he was an addict originally as well, and things spiraled before he knew it. He was certainly in too deep. He does have significant health issues, significant nerve damage through his back, and is currently risking some permanent nerve damage in his hand. The court is aware of his most recent injury. I would ask the court to take all of that into consideration. I would also ask that the court recognize his lack of record when sentencing accordingly. I believe that the individuals the state spoke of did have more significant records than Mr. Johnson. I would argue here, Your Honor, that the minimum sanctions of these mandatory sentences are appropriate, and ask the court to do the same. Thank you.
Mr. Johnson, is there anything you would like to say? You're not required to speak, but if you would like to speak, the court will hear whatever you have to say.
No, sir. No, Your Honor.
All right, well, this is, the case against you is overwhelming, no question about it. Jury took a while to go through a lot of the things in terms of forfeiture and so forth, but, you know, they had indicated just a few minutes before 11 they did reach a verdict already, and they had to fix a jury form, so we sent them back another form, blank form to execute. And then they went on to do the rest of their work. And it's clear that your occupation is drug dealer. There's no other way to put it. I don't doubt you have physical issues, but you know, the fact is you're a drug dealer, and you've been dealing drugs, and you know, based upon the fact the neighbors were, you know, appears like everybody in the neighborhood knew it. And if the sheriff had, if they just spent a little more time, they probably would have got a lot more advice from you, but they didn't think they needed to do it. I don't disagree with the decision. I think they did what they needed to do. And then after this July 12th search warrant, you didn't scale back your operation, obviously, because when you got stopped on the 12th of September, you had more drugs with you, and more black books, and more, well, and a pink book, and you know, quite honestly, you have one of the more sophisticated record-keeping systems of drug dealers that have actually gone to trial, where I've heard testimony about that. So there's no question you're a significant drug dealer, and you know, it's important to the safety of this community that that they be protected from you, as well as the fact you should be punished for what you've had. Now, I know you do have at least one prior felony conviction, Ross County, and you've served one previous prison term, right?
Yes, sir.
Okay. But even if that weren't the case, somebody that deals as much as you've been doing, and the extent to which you deal, it's clear that you need to be held accountable. So, with regards to count 1, engaging in a pattern of corrupt activity, it's ordered that you serve a term of incarceration, Corrections Reception Center in Ohio for later assignment of 10 years. With regard to count 2, you're ordered to serve a sentence of 8 years. With regard to count 4, you are ordered to serve a sentence of 9 months. Count 6, you're ordered to serve a sentence of 9 months. Count 7, you're ordered to serve a sentence of 12 months. Count 8, you're ordered to serve a sentence of 30 days in the Highland County Jail. That will run concurrent with the other sentences that are being imposed for the felonies. With regard to count 9, you're sentenced to serve a term of 9 months. With regard to count 10, you're ordered to serve a sentence of 9 months. And with regard to count 11, a sentence of 9 months. Each of those sentences are ordered to be served consecutively to one another. The reason for that is the court finds that your conduct occurred as 2 or more courses of conduct with 2 different dates involved. Plus, it's clear that the pattern of corrupt activity occurred over an extended period of time. Ms. Brigner had indicated, you know, a couple of years that she was with you. And that would seem to be the case based upon all the information that was accumulated in this investigation. The court also finds that this conduct is such, together with your previous conviction, that is necessary for protection of the public. The court further find that the sentences that are being imposed are not, one single sentence would not adequately reflect the seriousness of the crimes that you have committed, and therefore consecutive sentence is appropriate and justified under the circumstances. Now, with regard to count 1 only, under the Reagan-Tokes law, I have sentenced you to serve 10 years. That is a minimum, and I believe that's a mandatory sentence, isn't it?
It is, Your Honor.
And, counts 1 and 2, failed to say, are both mandatory sentences, so that's a mandatory 18 years. Now, as to count 1, and let me go back, the other sentences are not mandatory, but counts 1 and 2 are. Now, with regard to count 1 only, under the Reagan-Tokes law, the Department of Rehabilitation Corrections could, at their discretion, based upon the law, extend that term for up to 50%. So that means that the maximum sentence on count 1 could end up being 10 years, or 15 years. It would be 10 plus 5, or 50% or half, which would be the additional 5. Now, I believe there are mandatory fines. Mandatory fines on count 1 and 2 are, I believe, $10,000.
They are, Your Honor.
All right. So it's ordered that you pay a fine of $10,000 as to each of those 2 counts, be payable to the, still to the Highland County Drug Enforcement Fund, isn't it?
Mandatory drug fund.
Mandatory drug fund. I couldn't remember if they changed the name or not. All right. With regard to the other counts, I'll not impose any fine on those. And I'll not impose any driving suspension. You don't have a license anyway, and you're not going to be needing one. Now, with regard to, well, and let me back up. Upon completion of the prison terms on count 1 and 2, there will be a mandatory post-release control of at least 18 months to 3 years, isn't it? I believe, for a F1.
That's not a sex offense, yes. No.
Yeah, it's not a sex offense, so it's 18 months to 3 years.
Yes.
Isn't it? So you'll be on post-release control for at least 18 months and potentially up to 3 years, which means you'll be supervised under the term set by the adult parole authority by a parole officer, and if they determine that you have failed to comply with those conditions, then they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term for all violations. However, if you commit a violation while under post-release control, then in addition, whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. Now, and again, just to go back to clarify, the consecutive sentences are for the felonies only. Count 8 by operational law is served. The 30-day misdemeanor is served concurrently. Now, with regard to the other felony convictions, not the count 8, but all the others, those in those situations, those are optional post-release control. And I have a case out of 4th District says I'm supposed to tell you that as well. So that's why I'm telling you that, although it doesn't matter because it's optional up to 2 years. But we already know you're mandatory on count 1 and 2 for 18 months to 3 years. But so it could be optional up to 2 years, but everything else I just explained to you does apply. Now, with regard to the forfeiture, it's ordered that all of those items in count 12 that were found to be subject to forfeiture are forfeited to the Highland County Task Force.
And the sheriff's office and prosecutor's office.
Sheriff and prosecutor?
Yes.
All right. Do you have a breakdown on that?
It'll be 25% goes to the task force first, and then the remainder is split between the sheriff's office and the prosecutor's office, 75% to the sheriff's office and 25% to the prosecutor's office.
So 75% of 75%?
Yes.
All right. And what is the math on that? You're doing it. You should
We
have
will
it.
prepare an entry, Judge.
All right. Put that in there. You do the math.
Yes,
All
we
right.
will.
And the prosecutor gets 25% of 75%.
Yes.
All right. Now, you're also ordered to pay the court cost, Mr. Johnson, which judgment, grant, and execution is ordered. If you fail to do that, the court clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you could be permitted to do community service, but that would not be until you're out of prison, so that's probably not going to happen. But in the event that it's unpaid when you do get released, then you could do community service in this county and be given credit for each hour you work, and an hourly rate set by the court each hour you work to reduce your judgment by that amount until paid in full. All right, now, Mr. Johnson, you have a right to appeal the verdicts of the jury and the sentence of the court. That appeal must be filed within 30 days of your sentencing entry being filed. Most likely be today. I would assume you'll get that entry done today.
Yes, Your Honor.
And it'll be put on record this afternoon. So you'll have 30 days to do that. You have a right to have the proceedings, the record of the proceedings, transcripts of the hearings and the trial, and all the papers that have been filed in the case for purposes of prosecuting that appeal. If you do not have the funds to pay for those, then on a proof of indigency, those will be provided to you at no cost. You also have a right to have an attorney to represent you in this matter. And if you cannot afford to hire an attorney to do that, the court will appoint one for you again upon proof of indigency. Now, typically, the attorney that handles the trials are not the appellate counsel, but I would ask you to discuss this with your Ms. Menzik, and if you are wanting to take an appeal, if you could file that notice for limited purpose of filing that, just protect his rights within the 30-day period, and then or if he has new counsel within that 30-day period that's retained, they can file it. If you don't have the money to have a counsel, then I want her to file a notice of appeal, and then the court will find an attorney for you, if that's the case.
For the record, Your Honor, we would ask that Mr. Johnson be found indigent and that the court appoint counsel for purposes of appeal at this time.
Well, he's going to have to fill out an affidavit, a financial disclosure form.
Yes, Your Honor.
So if you have him do that out to the sheriff's office, Lieutenant, and we'll take a look at that. Do you own any other real estate other than what's been, there was testimony about a real estate in Humboldt. Do you own real estate in Humboldt?
No, Your Honor.
You own any real estate at all?
No,
You own any vehicles?
no.
All right. You have any bank accounts? Do you have any bank accounts?
Yeah, a little one,
How much is in it?
probably $600.
Okay. All right, well, you fill out the form out to jail and send it up, and then the court will attempt to find you an attorney. I think, again, just protect the record, if you would go ahead and file it, Ms. Menzik, because, you wish to file an appeal?
Yes.
All right. Because we it's getting more difficult to find appellate attorneys. It's usually we have to reach out to either the public defender or someone else that works with the public defender, and so I just want to make sure that it's filed so we don't have to deal with asking for a delayed appeal with the Court of Appeals.
Absolutely.
Okay. Anything further from counsel?
No, Your Honor.
All right, you're remanded in custody.
Yes, sir.
All right. This is case number 23, CR 58, State of Ohio versus Bradley Allen Clark. His attorney is Dennis Kirk, who's present in the courtroom, along with Assistant Prosecutor King. And Mr. Kirk, did you have an opportunity to talk? All right. Mr. Clark's charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. I believe this would be the first pretrial. And in fact, our final pretrial set on July 19, and a trial date on August the 7th. I see the state's provided bill of particulars of discovery. Your discovery will be due by final pretrial, Mr. Kirk.
Okay.
Do you anticipate any pretrial motions?
Not at this time.
All right. And has there been a plea offer received?
There has, and I did relay that today via the video to my client.
All right. Are there any other matters then we need to discuss at this time?
Nothing from the state, Your
No,
Honor.
Your Honor.
All right. Mr. Clark will return you from the institution for your final pretrial on July the 19th.
All right.
All right. Thank you. This is case number 19 CR 135, State of Ohio versus Timothy Corlonis. Let's see here. Oh, there it is. All right. Mr. Corlonis was placed on community control on June the 5th of 2023 on a charge of aggravated possession of methamphetamine, a third-degree felony. Now, there was a notification filed on the 30th of June, Mr. Corlonis, by the probation department that alleges that you have violated Rule 2, that you failed to report since April 12, 2023, even before it put you on community control. That on or about 6/29/23, you denied taking a drug screen by the officer, probation officer, while at jail. Rule 11, you were arrested on June the 6th and on charges of theft and criminal trespassing and failed to financial costs, the court costs. So it looks like this was filled out this morning, and looks like you signed a copy this morning. Is that correct?
Yes.
All right. Now, Mr. Corlonis, you're entitled to have a hearing in this matter, in which the state will be required to present evidence that proves to the court's satisfaction that you have committed these violations. You have a right to have an attorney to represent you, and if you cannot afford to hire counsel, the court will appoint one for you. And I see that you did fill out a financial disclosure form. Is everything on this form correct?
Yes.
All right. The court then will find that you are entitled to counsel. And let's see here. All right, the court appoints Attorney Catherine Hampton to represent you. There will be no bond, and you'll be held in custody pending hearing, which evidentiary hearing, which will be July the 6th at 2 p.m., assuming Ms. Hackner is available. If she's not, it may need to be continued. We'll inform her of her appointment, and she'll be in contact with you. You have any questions?
Your Honor, is there any way that I can have an OR or a furlough? I'm in a wheelchair.
Yeah, I can see her in a wheelchair. I'm not blind.
Well, I've got several medical problems that's wrong with me. I'm unable to lay.
Well, let me say this. You know, if you had been reporting and doing what you were supposed to be doing, you wouldn't be in jail. So why would I let you out to do the same thing all over again? Yeah, I may look dumb, but I'm not as dumb as I look. So the answer to that's no. All right.
Your Honor,
Would you bring in
Mr.
Mr. Jason Storr,
That's
please?
when I had back.
I'm done with you, Mr. Corlonis. I said no. Don't argue with me. He'll take you out. We'll bring in our next case. Thank you.
Yeah.
Okay, now this guy is, okay, he's the one that has victims, okay.
Absolutely there, sir.
This is an arraignment. We get a red jacket on this already. All right, are you Jason L. Storr, appearing there from the jail?
Yes, sir.
All right, Mr.
Jason
Storr,
Hazel.
you were indicted by the grand jury on June the 6th in 2 cases. Case number 23 CR 53 is for breaking, entering, and theft. For 23 CR 101, it's aggravated possession of methamphetamine. Now, with regard to state case number 23 CR 53, the assistant prosecutor, Mr. King, is present for this arraignment. And Mr. King, was the alleged victim of this offense, notified of the time, place, and purpose of this hearing and the opportunity to, the right to confer with the state regarding the matter?
Yes, sir, Your Honor, and he indicated that he would not be present today.
All right, thank you. All right, now case number 23 CR 53, Mr. Storr, you were indicted for breaking and entering, which alleges in count 1 that on or about February 19, 2023 in this county, you knowingly, by force, stealth, or deception, trespassed in a business at 209 South High Street, Hillsborough, with purpose to commit the theft offense. Count 2 alleges on or about the same date in the same county, you did with purpose to deprive the owner, Rusty Hill, of property, knowingly obtained exert control over that property, antiques, jewelry, and other items having a value of over $1,000, less than $7,500. All right, each of those offenses are 5th-degree felonies, which carry a possible prison term between 6 and 12 months and a fine of $2,500. Now, with regard to case number 23 CR 101, you are charged with aggravated possession of methamphetamine, alleging that on or about March 2nd in this county, of this year in this county, you did knowingly obtain, possess, or use methamphetamine. Now, you are entitled to have an attorney to represent you, and if you cannot afford to hire one, the court will appoint one for you. And I see you did fill out a financial disclosure form, I believe. I know because I wrote the case number on it. Here it is. All right. It says you are working at Anything Concrete, making $2,000 a month. Is that correct?
Yes, sir.
All right. All right. Did you have an attorney in the municipal court on this case?
Yeah.
And who was that? Do you remember?
Well, they had two of them.
I can't hear you. Who?
They had 2 different ones. Then they.
Wait a minute. Let me turn this up. Okay. Who was it?
I don't really know who it was. They had 2 of them, and then they switched it around because of conflict of interest.
Okay. Well, it couldn't be him because I believe, didn't he represent Mr. Hill?
No, that was Mr. Wagner.
Oh, Mr. Wagner had Mr. Hill? Okay. All right. All right, then the court will appoint Attorney William Armentrout to represent you in each case and enter a not guilty plea on your behalf. Now, Mr. Storr, I know you posted a bond in the first case. The reason you were arrested is because they were not able to serve you. Where are you living?
I'm living with my son
Okay,
in
that's a
Hillsborough.
person, not a where. Who or what is
At Hillsborough, Ohio.
Pardon me?
12466 Ladd Road.
And is that a Bainbridge address?
That's a Hillsborough address.
Hillsborough, all right. How long have you been living there?
Roughly about a year.
All right, well, I'm not sure why they couldn't serve you with this. I'm thinking that it was, this is one that was supposed to be in Lincoln County or not, but in any event. All right, I'm going to go ahead and continue to release you on that bond, $5,000 bond. Plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if
Yes, sir.
sentenced on that, no matter what happens in this case. Now, you'll also be be required to pay a deposit of the service fee deposit of $171 plus within 30 days of your release.
Yes, sir.
Now, if you fail to appear, then you could be prosecuted for an additional felony and a conviction sentence on that, regardless of what happens in this case. Now, in case number 23 CR 101, I'm going to go ahead and release you on your own R only, but you'll also have to pay a deposit within $171 to the clerk. In that case, those are secure payment of statutory required fees. You're under pretrial supervision of the probation department's conditions of bond, so you report to them immediately after court, after you're released. You know where that's located.
Yes, sir.
All right. Now, if you don't get there before 4 o'clock when they close, then you report Monday morning. Understand?
Yes, sir.
Now, you're to report once a week for 4 weeks. After that, as they determine, undergo random drug testing, provide phone numbers for home, cell, and employer, not to have any contact with the alleged victim in 23 CR 53. Recommended by probation, you'll be evaluated for substance abuse and mental health issues. If any treatment's indicated, you'll enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 12466 Ladd Road, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, to attend any kind of job training, educational programming, etc., or church services. Other than that, you have to be there at all times. And if you fail to comply, then the court could revoke the bond and have you held to further order of the court. Now, the court will enter a not guilty plea in each case on your behalf. In the absence of counsel, we will set your first pretrial for July the 19th at 2:15 p.m. Final pretrial will be August 2nd on both cases at 2:15 p.m. And your jury trial, we'll set them together, although if you have two trials, they'll probably have to be separated. It'll be set tentatively for August the 28th at 8 a.m. All right. We'll notify your attorney of his appointment. You can get his phone number from the jail there. If you have any questions?
No, sir.
All right, then you report to the probation department immediately. All right, thank you.
Yes, sir. Thank you.